Hi there, this is Jonathan Ginsberg, and I'd like to discuss a question that comes up periodically from clients and prospective clients, and that is, can I dismiss a Chapter 7 once I've filed it? And the quick answer is no. You cannot voluntarily dismiss a Chapter 7. You can get an order of dismissal from the court, but you cannot simply go into court and say, no harm, no foul, I changed my mind, and I don't want to be here. And the reason for that is Section 707 of the Bankruptcy Code specifically requires a judge to dismiss your Chapter 7. Now, this is very different than Chapter 13. In Chapter 13, generally, you have the right to go in and simply say, I changed my mind, I want to dismiss my Chapter 13. Chapter 7 does not work that way. And of course, the reasons that you might want to dismiss a Chapter 7 could be a number of things. For example, some of the things I've seen, after you file, you may realize that you actually have an asset that's at risk. There's an asset that you have that has a lot of value. You want to protect it, and you realize in a Chapter 7, the trustee is very likely to go in and take that asset and sell it, and you want to avoid that. Perhaps you've incurred new debts. I read about a case recently where a debtor filed Chapter 7. About 2 weeks after that person filed, he got into a car accident. There was apparently some insurance issues, and the debtor ended up owing a good bit of money from the car accident. Wanted to file bankruptcy, wanted to include that post-petition debt, obviously couldn't do it in his existing case, wanted to dismiss it so he could then refile a new Chapter 7 to include the new debt. And the judge said, no, can't do that. So that's not going to work. You can't dismiss to include a debt you forgot to include the first time. Or you could simply say, I just changed my mind. I realize that bankruptcy can be somewhat intrusive. I don't want to be in bankruptcy, and I just changed my mind. But again, the law says you cannot simply voluntarily dismiss the case and say, I want to go back and put things back the way they were. And actually, not being able to dismiss, it can really have some pretty harsh results. So let me tell you about a case I had. This is probably going back about 20 years, but this is one that really kind of illustrates the harshness of the rule that you cannot voluntarily dismiss. I got a call from a gentleman who was actually out of town at the time, and he had filed a pro se Chapter 7, meaning he had gone to court, gotten the forms at an office supply store. He had filed a Chapter 7. He was about to be garnished. He wanted to stop that. So he filed a Chapter 7, and when we looked at it, he came in and said, you know, I've changed my mind, I want to dismiss it. The problem, it turns out, was that his mother had quitclaimed part interest in her house, and the mom had a house worth $100,000, let's say, and that was free and clear. And the mother had quitclaimed partial interest to her son for estate planning purposes. So now the son has an undivided half interest in this property. Well, I called the trustee, and he said no. He said, I think that the son has interest in this house, and I'm going to pursue liquidating this asset. So basically, the trustee's message was, you know, Mom, you're going to have to sell your house so you can buy me out of my interest. The trustee actually representing the bankruptcy estate, and the estate had an interest roughly $50,000, although it doesn't have to be half, but in this case, roughly $50,000. So the end result was my client and his mother had to go and refinance the house, take a house that was free and clear, take out a loan on it, and generate, I think it was $40,000 or $50,000 to pay the trustee, to buy the trustee out of the estate's interest. So that was a very expensive lesson for this guy. Of course, he still ended up having the garnishment issue to deal with, and he put his mom in a real difficult situation with regard to her house. Now you can, if you can't dismiss it, you can convert it to a Chapter 13 and use the Chapter 13 to pay back debts that, to the extent that they would have been paid, your creditors to the extent they would have been paid in Chapter 7. But you cannot simply walk in and voluntarily dismiss a Chapter 7 without permission from the court. And my experience has been that if you decide you want to try to dismiss it, the judge is going to be very suspicious. Why do you want to dismiss it? What are you hiding? So I would not count on that. Certainly, at a minimum, I would not try to simply file a piece of paper that says voluntarily dismiss my Chapter 7 without an attorney. That's not a good idea. And I think that before going into Chapter 7, you and your attorney need to really discuss in detail what the implications are. Take a look at your credit report, take a look at your list of assets to make sure there's no surprises, even to the point of being aware that there may be somebody who might leave you money. One of the questions that trustees ask in meetings with creditors hearings is, do you expect to inherit any money? And if you inherit any money within 6 months of the case being dismissed, you're obligated to report that to the trustee. The trustee will then reopen the case and liquidate that asset. And I've actually had that happen. It happened to me a year ago, where a client of mine had an inheritance that he got after the bankruptcy was filed, and the trustee went back in, reopened the case, and is liquidating that asset. So there are a lot of implications to Chapter 7. You cannot simply walk away from it if you don't like it. And again, this is something that you should really have an attorney to discuss what happens when you file, and what the positive and the negative about filing. But walking away is certainly just not an option. So I hope that's answered the question about voluntarily dismissing Chapter 7. If you have any questions, drop me an email, give me a call. I'll be happy to discuss it further. So this is Jonathan Ginsberg, and we look forward to talking to you soon.